Welcome back. In our last session, we talked about the will as your foundation document. It's your voice, your safety net, and your roadmap for the court. But even the most powerful tools have boundaries. Today, we are going to explore the boundaries of your will. Let's start with one of the biggest misconceptions. When a will actually takes effect. A will is a post-death document. It has zero authority while you are still alive. That means naming someone in your will does not give them the power to act for you if you become sick or injured. If you were to face a period of incapacity, meaning you're alive but unable to make your own medical or financial decisions, your will cannot help you. Naming an executor in your will doesn't give that person the right to pay your bills or talk to your doctors while you're in the hospital. For those situations, you need living documents like a power of attorney or a healthcare directive, which we will cover in future lessons. Now, let's talk about non-probate assets. Many people assume their will covers everything they own, but in reality, your will only controls your probate estate, which are the items you own alone that don't have a specific beneficiary named. Here's where people get tripped up. If an account has a beneficiary listed, or a joint owner, that designation usually controls who receives it. Even if a will says something different, the name on the account may still win. The name on the account almost always wins over the name in the will. If your will says your savings should go to your children, but your retirement account still lists a former spouse or a sibling as the beneficiary, the financial institution is legally bound to give the money to the person named on the account. The will cannot override a valid beneficiary designation or a property titled in joint tenancy. This is why reviewing beneficiary designations is such an important part of planning. A will doesn't replace them. It works alongside them. Another boundary involves the location of your assets. A probate court in the state where you live generally only has authority over property located in that same state. If you own a vacation home in another state or a piece of land in another country, your executor may have to start a second, separate legal action called ancillary probate just to handle that one item. It's a hurdle that a will alone cannot leap over, though other tools like trusts can help you avoid it. Now let's talk about probate itself. Probate is the court process that confirms someone has died, validates the will, pays debts, and oversees distribution of probate assets. A will does not avoid probate. In fact, a will is what often triggers probate. That doesn't necessarily make probate bad, it just makes it important to understand. Some people choose other tools to reduce or avoid probate, and we'll explore those options later. For now, the key takeaway is that a will does not skip this process. Here's another important point to consider. Your will does not give you completely free rein to do anything you choose. It must follow the laws of the state where you are a legal resident at the time you die. And let me re-emphasize that last point. The state laws that apply are the laws of the state where you are legally living when you die, not the state where your will was originally drafted. That's why moving to a new state is a natural moment to revisit your estate documents. A will that worked well in one state may function very differently in another, especially in states with distinctive inheritance laws, like Louisiana. Each state may have different helping hand laws designed to protect your closest family members and assist with minor errors in your will. For example, most states have spousal elective share laws that could prevent you from leaving a spouse entirely penniless and may grant them the right to claim a certain amount of your estate, regardless of what your will says. There are also rules for oops situations, like if you have a child after your will is signed, but forget to update it. State laws may step in to ensure that child is still provided for. There are also laws to determine how gifts in a will may be reduced if the estate is not large enough to pay debts and fulfill all bequests, called abatement laws. There are laws to address if a beneficiary dies before you do, or if you get divorced but fail to change your estate plans. There are even laws to protect your family's right to remain in the home and receive temporary financial support while your will is being probated. You might also have existing contracts that act as borders for your will. If you have a prenuptial agreement or a divorce decree, those documents may legally obligate you to leave certain assets to specific people. If your will conflicts with those legal promises, it could lead to your estate being contested in court. Hopefully, you are now beginning to understand what a will can do, and the outside rules that may shape how it works. If you want to take a small, meaningful next step today, start with reflection. Think about whether you already have a will, and if so, when it was created. Consider whether anything important has changed since then, like moving to a new state, getting married, divorced, or signing a marriage contract such as a prenuptial or postnuptial agreement. These kinds of changes don't mean your will is wrong, but they may influence how it operates. Next, pause and think about your wishes at a high level. Are there people or outcomes that matter most to you? Now consider whether any state-level rules, like spousal rights, community property laws, or protections for children, might interact with those wishes. You're not looking for answers yet. You're simply noticing where questions or possible conflicts might exist. If you'd like to go further, explore the optional resources that walk through common state law categories in plain language. These tools are designed to help you understand what to look for and which questions are worth asking. We also have a lesson later in the unit that goes more in-depth into state laws that could affect your planning. And remember, understanding how the pieces fit together is one of the most important parts of planning.